Tonight on Legislative Review. Healthcare insurance reporting. Plus, felony sentencing for caregivers. And tribal elder education. From Olympia, this is Legislative Review. Thanks for watching Legislative Review, your source for daily highlights in the state legislature. I'm Angela Nolasco. Our coverage today starts with a Senate committee discussion.
Good morning. Welcome to the first committee hearing of the 2025 legislative session of the Senate Health.
The Senate Health and Long-Term Care Committee held a public hearing Thursday morning to discuss a bill proposing to direct the Office of the Insurance Commissioner, OIC, to consider existing primary care expenditures when determining information reported by a healthcare insurance provider. The bill aims to modify the existing process by urging the OIC to review recommendations by the Healthcare Cost Transparency Board under the Healthcare Authority. Democratic Senator June Robinson sponsored the bill. She said it's a matter of healthcare affordability.
To affect affordability and access, we have to push towards more investment in primary care. And there is evidence to support that it improves health, it improves access, and leads to lower costs overall in the healthcare system.
Testifying on behalf of the OIC, Nico Jansen said the bill simply allows a change in the current statute so that the OIC can require healthcare insurance to report primary care spending.
Essentially, this bill would match up how the OIC and the Healthcare Authority are tracking insurers' primary care spending across the health insurance markets that the state regulates. Current law gives the OIC authority to collect primary care spending through our review of insurer rate and form filings. However, in practice, this method has presented some technical challenges for the OIC.
In a remote testimony, primary care Dr. Jonathan Staloff of the Washington Academy of Family Physicians offered his perspective to the committee.
Both nationally and in Washington state, we underinvest in primary care. This bill represents an important step in helping the state move toward measuring and understanding the level of investment in primary care. This bill would provide Washington's Office of the Insurance Commissioner that essential visibility so we can know overall the landscape of primary care spend.
The bill also received support from the nonprofit group Washington Insulin for All. No one testified against the bill.
A strong family structure can reduce recidivism, which is why the caregiver status is believed to be a mitigating factor.
The Senate Law and Justice Committee met Thursday to discuss a bill that, if passed, would allow courts to decide a defendant's sentence based on their status as a primary caregiver. Under current law, the Sentencing Reforming Act allows the courts to determine sentences in felony cases outside of their standard range if there are mitigating circumstances or compelling reasons to do so. Senate Bill 5133 aims to enable judges to include a defendant's status as a caregiver, parent, or legal guardian as a mitigating circumstance by which the court can determine their sentencing. The bill's prime sponsor, Democratic Senator Claire Wilson, cited a study that showed single incarcerated mothers are more likely to be their children's primary caregivers than male fathers.
And they are also significantly less likely than incarcerated fathers to have another parent or a family member available to step in and care for their children, for other family members or dependents during their incarceration. Failing to recognize caregiver status as a mitigating factor, I think, adversely impacts those who generally carry the burden. We know that incarceration can have lifelong adverse consequences, not only for those individuals who are incarcerated and their parents, but their children, their loved ones, and their children's caregivers.
Senate Bill 5133 is an agency request bill submitted by the Administrative Office of the Courts.
This is still subject to judicial discretion, so it's not mandatory and it's not automatic. So judges will take into consideration all the facts before deciding if it's appropriate.
Russell Brown of the Washington Association of Prosecuting Attorneys testified with concerns about the bill.
As someone could seek a mitigated sentence if they were the parent who was abusing a child. You murdered your girlfriend and you are now the primary custodian of the children. We don't think that's what the thought is behind this, but the language is broad enough, particularly when those others are very narrowly tailored. When we read the language in this bill, it's really broad. And I think a court could consider the fact that the legislature knows how to narrowly tailor particular language. They've done that with the parent sentencing alternative or the community parenting alternative, and limit types of crimes that would apply, types of dynamics, types of timeframes.
And we are now going to hear from the last testifier on this bill, Cindy Ahrens.
The bill received support from the Washington Defender Association and the Washington Association of Criminal Defense Lawyers.
When a person is facing a prison sentence, the judge should be permitted to consider all impact of the sentence, not just the culpability for the crime or the circumstances of the crime, but the circumstances of the individual and their family. People deserve not just a just sentence, but they deserve a sentence that is imposed in a just manner.
When you see an elder attending a college, going back to school, that is an inspiration for another generation.
The Senate Higher Education Workforce Committee held a public hearing Thursday afternoon on a bill that would give tribal elders a tuition waiver while attending Washington's community and technical colleges. Sponsored by Senator Claudia Kaufman, Senate Bill 5110 aims to waive all or a portion of tuition fees and all services and activity fees for tribal elders over 55 years old who belong to federally recognized tribes.
Seniors do have an opportunity for tuition waivers in the state community technical college system. That begins at age 60. The life expectancy for American Indians is 65. This is not only appropriate for the demographics, but it's also culturally appropriate for the community.
Senate Bill 5110 received support from AARP.
High prices and inflation continuing to impact everything from housing costs to groceries. It's no surprise older adults are looking to increase their income and their opportunities. We know that COVID is still a challenge for a lot of older adults who are struggling after the pandemic and to get back into the workforce, also facing age discrimination. We hope that this bill will be passed and that tribal elders will be able to have access to all the incredible training programs. We have the data that shows it works.
Also testifying to support the bill, Maya Escovedo of the Washington State Board for Community and Technical Colleges.
This bill would be lowering the previous age from 60. This change would be an important step toward recognizing the unique contributions and needs of Indigenous communities in our educational system. Access to tuition waivers would help ensure that they have the chance to further their education regardless of the short life expectancy or other socioeconomic barriers they may face.
No one testified against the bill. To watch all the hearings covered in this episode, as well as gavel-to-gavel coverage of the 2025 legislative session, visit our website at tvw.org. That's a wrap for us tonight. Stay with us throughout the legislative session, where we bring you all the top debates right here on Legislative Review. We'll see you tomorrow.